Good afternoon to all the viewers of KCGC TV. Myself, Dr. Anita Sharma, Assistant Professor, Khalsa College of Law. Today, my topic of discussion is alternative dispute resolution with special reference to arbitration. Now, first of all, what is alternative dispute resolution? Alternative dispute resolution is an external form of dispute resolution, that is in which you resolve your cases out of the court with the help of mediation, negotiation and conciliation, etc. Now, area system is one of the system which you can seek out of the court, that is if a person don't want to go to the court and to seek the advice, or the dispute can be resolved with the help of some alternative disputes, that is other than the court you can resolve your case with the help of a third neutral person who is an expert in dealing with the particular kind of cases, dealing with mediation or negotiation, etc. It means that you need not have to go to the courts and you can take the help of the other alternative disputes, that is etc., like mediation, arbitration, negotiation, conciliation, etc. Now, we can basic features or basic characteristics of alternative disputes resolution are that the ADR system, it operates directly, that is no representation of the parties is required. You the alternative dispute resolution, you can participation of the disputants are directly, you need not have to hire an advocate to resolve your case, and the direct participation of the disputants are there. Directly you can fight your case by participating, and direct representation is there. Then the next thing is that under your ADR or the alternative dispute resolution, there is the doctrine of equity. Now, what is doctrine of equity? Doctrine of equity is that when you file a case in the court, there is the decision in one person's favor and the other person loses the case. But according to your ADR, or when you solve, or you in according to your arbitration or negotiation mediation, both the parties are benefited, and according to your ADR system, if any case is solved, then both the parties are benefited. It means that the results given by the ADR system are effective and efficient. Then there is the direct participation also, and direct dialogue delivery between the parties and the disputants. There is the communication between the disputants also. In the procedure of the court, there is no direct participation, or there is no direct dialogue delivery or the communication between the disputant, but under your ADR system the parties can communicate between themselves also, because under court system only you can communicate with your advocate, but in your ADR system, let it be through mediation, etc., then you can have even the communication between the parties are also there. And basically ADR system or alternative dispute resolution, which is the requirement of today, is that basic features, or you can say the benefits of the ADR system are that it is less time consuming and less expensive, and moreover it is more beneficial to the person or the disputant, because more formalities are not involved under your ADR system. And that is basically when you go to the courts, then under your courts, that is you will have to follow all the procedures are followed, that is law of evidence, CRPC, CPC, all formalities are involved, and all the persons are unable to understand all the formalities which are involved under your ADR system or under your court. So, you can shift onto the ADR system, and because under ADR system no formalities are involved, and the parties can directly participate and they can equally participate, and the results given by the mediation or arbitration, etc., they are effective and efficient to the parties. Nowadays our judiciary are overburdened, more and more cases are pending in the judiciary. So with the help of ADR system, that is through mediation, arbitration, negotiation or conciliation, you can shift the burden of the judiciary, and you can shift the burden of the judiciary can be shifted, and the cases can be solved with the help of ADR system in effective and efficient manners. Now coming to the arbitration. Nowadays arbitration is one of the ADR system, which is very much particular and popular in our country and in the international level. Article 2 subclause 1 of Arbitration and Conciliation Act, it provides the arbitration, and arbitration means that any party in your trade or commerce or commercial activities, the arbitration can be made a clause, that is an agreement can be made by the parties to resolve their cases with the help of the arbitration. Arbitration according to Article 2 subclause 1 of the Arbitration and Conciliation Act is that if there is any kind of dispute between the parties or there is differences or dispute, then it can be solved with the help of the arbitration. An arbitration clause can be written in the agreement, and in case of any difference, even in differences or the dispute, it can be solved with the help of the arbitrator or arbitrators which are appointed by the parties, or even the courts appoints the arbitrators for the sake of the parties. So, the Arbitration and Conciliation Act 1996, it provides the provision of the arbitration, because nowadays there is a very much large wide of trade and commerce and communication, and due to which the people are engaging in the trade. There can be a sort of dispute and differences, and the parties, they don't want to go to the courts to seek the any kind of justice. So, in that case, the parties can take the help of the arbitration. They can add a clause in their agreement that in case of in the future, in case of any differences which have existed or which can exist in the future, they can go to the arbitration, and the arbitrators are appointed with the consent of the parties voluntarily and with the consent of both the parties, so that in case of any future dispute arises in your transaction or in your business, then you will have to go to the arbitrator, and the decision which is given by the arbitrator, they are binding on the parties. Now come the arbitration, there is arbitration agreement also. Arbitration agreement can be written in your agreement clause also, and also as a separate arbitration agreement can also be written, in which terms and conditions are written that in case of any difference or dispute which can arise in the future, they will be abide by the arbitrator which are appointed with the help of the parties or with the consent of the party. It means that the outcome of the results which are effective and efficient, it is in the hands of the parties only, and the parties are able to resolve their cases with the help of the arbitrators which are priorly appointed by the parties, so that it is easy to resolve your case with the help of the arbitration and need not have to go to the courts, and effective and efficient results can be given by the arbitrator. Now coming to the next is what is important for the arbitration or the arbitration clause, that arbitration, it should always be in the writing form. Arbitration should not be in the oral form or verbal form, it should always be in the writing form, in a writing document. Then the second thing is that the intention of the parties should be to go on for the arbitration. It means that it is not a compulsory process, or it is the intention of the parties should be to go by the in case in the future if any difference or dispute arises between the parties regarding their any trade or business, then they will go to the arbitrator which have been appointed by them. Then it means intention or ad idem means the intention of the mind of the parties should be similar, and they should be abide by the differences. Now arbitration means that according to section 2 subclause 1 of Arbitration and Conciliation Act, basically the definition of arbitration has not been given, but the arbitration means it is the difference or the dispute which can be solved in a mutual way, mutual understanding, which settles the rights and the liabilities of the parties in a judicial manner, and it is binding on the parties, so that in a better way you need not have to go to the courts, and you can abide by the arbitration clause or the arbitrators. Now coming to the scope of arbitration under today's scenario, okay, due to the globalization, increase in trade and commerce, economic reforms, needs to be, should be an effective economic reform. So looking at all these features, the old Arbitration Act 1940 has been replaced by the new Arbitration and Conciliation Act 1996. Under your new Arbitration and Conciliation Act 1996, in both the provisions of arbitration as well as conciliation provisions are given under it. Now, according to your Arbitration and Conciliation Act, it means that because due to the increase of globalization and the economic reforms, both the India and other, India is with the other foreign countries, they are at the trade and business, and there is interchange of trade, commerce, business, and the multinational companies are pouring into the India business like telecommunications, then construction business, etc. And there is an interaction regarding to your commercial activities between India and the foreign countries. So under this, you can resolve your case. It means if some differences or dispute arises, you can solve it through the arbitration. Both the parties or both the countries can have an arbitration agreement under your agreement arbitration clause, that in case of any difference or dispute which may arise in the future, you can go abide by the arbitrator, which will be appointed by the parties themselves voluntarily, and it will be easy that effective and efficient results will be given with the help of the arbitration, and it will be binding on the parties and better, so that nobody a proper effective and efficient results can be given to the parties. Now coming to the different kinds of the arbitration. Now arbitration, first of all, is there is the ad hoc arbitration. Ad hoc arbitration means that if suppose some dispute or differences arises between the parties and it is not probably solved by the parties amicably or settled by the parties amicably with the help of mediation or conciliation, etc., then the parties can go by the ad hoc arbitration. It means if it is not properly solved or amicably in a friendly manner, then they can go to the ad hoc arbitration. They can form in the meanwhile the ad hoc arbitration. Then the next is your institutional arbitration. This kind of arbitration is very popular in India. In this case, that priorly the parties appoint an institution as an arbitrator. It means that if there is a trade or commerce or there is a partnership between the parties, and they priorly appoint the arbitrators, they appoint the arbitrators and institutions which are expert in dealing with the arbitration clauses or which dealing with the trade and commerce, and they are expert persons. They are expert in case in the future if any kind of difference or dispute arises between the parties, then they can have recourse to the institutional arbitration, and they are expertise persons and they give the help to the parties. Then the third one is your contractual arbitration, which is very popular due to the globalization of the trade, commerce, activities, etc. More and more parties are involved under trade and business. Import and export transactions are going on, and more persons are involved under the trade and commerce. And so for that, it is required that persons in their agreement, they write a clause in which an arbitration agreement or an arbitration clause is written, in which they appoint the arbitrators, so that in future if any kind of difference or dispute arises, then they will be abide, they will go to the arbitrators which they have appointed, and they will not seek the recourse to the court, and they will abide by the recourse of the arbitrator which have been appointed by them, and so that the arbitrators are effective persons and they need not have to waste their time going to the courts, and it can be solved with the help of the expert persons who are appointed by the parties themselves. Then comes statutory arbitration. Now, statutory arbitration is different from the other types of arbitration. Statutory means that it is statutory arbitration, but it is the compulsory arbitration. It means then it is mandatory arbitration and the parties are bound to it. And it is that under your statutory arbitration, it is binding by the courts. courts appoint the arbitrators under it. It means that in other form of arbitrations, the parties are free or they voluntarily appoint the arbitrators, but under a statutory arbitration, the court appoints. It is with the parties. It is basically a compulsory form of the arbitrations, and the court appoints the consent of the party is not taken, and the court appoint the persons who are appointed by the courts. You are abide, and there is no kind of, it is not voluntary, and you are bound by the law of the land, and it is a compulsory form of the arbitration, and you have to abide by it. Then there is the next is the international arbitration. Now coming to the international arbitration, it means that international due to globalization, trade and commerce, there is a trade and commerce, intertrade commerce between foreign countries and our countries. There is the need of the arbitration between if there is a trade in between India and the foreign country, it means international. Suppose a person or a subject matter is out of India, then international arbitration is binding it, because if a party is of a foreign status and one party is Indian, then both the parties are not abide by the law, so they can go on for the international arbitration. An arbitration clause under it is written so that it is binding on the parties whose subject matter is in the other country, or suppose a company or corporate which is in the foreign national or corporate etc., then you can be abide by the international arbitration. Then comes is your domestic arbitration. Domestic arbitration is when the subject matter is basically situated within India. The subject matter is situated in India, cause of action has arisen in the India between both the parties, disputing parties, then you will be abide by the domestic arbitration, and the rules and regulations of India will be applicable to the parties. Then comes is your foreign arbitration. Now, when an arbitration proceedings takes place outside India, that is in some foreign country or some foreign place, then the foreign arbitration is binding, and the award of the foreign award is binding on the parties. The and it means that these are different kinds of arbitration through which the Arbitration and Conciliation Act 1996, under it different rules and regulations are formed, and any person can opt to one or the other form. Basically, the arbitration should always be in the writing form. It should never be in a oral form. Then the second thing is the intention of the party should be to abide by the rules and regulations of the arbitration and conciliation. It means that it is not a compulsory process. It is, you cannot only regarding your statutory, but it should be abide by the parties. It means ad idem, meeting of the mind, both the parties or the more than parties who are wishing, they will have to abide by, they are voluntarily willing to go abide by the arbitration clause, and the parties are binding by it. And second thing is the parties should be competent or to apply for the arbitration clause. If you go by the arbitration clause, the competent person should be of the sound mind, having a good health, and only then they can abide by the rules and the regulations, and it is binding on the parties. It means that it is a better way to go on by the arbitration to solve your cases in the modern days, that is due to increase of the trade and commerce. It is better to go on for the arbitration. Now, the arbitration can be in the agreement also itself, in the contractual agreement. If two or person might be, if they are going on for partnership firm or anything, any private company etc., they can have it can be a private nature also, and it can be by the operation of the law also. And the results or the decision which is given by the arbitration, it is called the arbitral award. It is not it is the arbitral award which is binding on the parties. Once you abide by it, it is binding on the parties, and you will have to abide by it. Now, Article 2 subclause C, it defines your arbitral award. Arbitral award, basically it is the decision which is given by the arbitration. So it is binding on the parties. Once you abide by it, then it is binding on the, once you have written down in your arbitration clause that you will be abide by the arbitration, then you will have to abide by the arbitration clause. An arbitral award, that is, it includes the interim award also. Interim award means that in case of any difference or dispute between the parties, if the arbitrator or they require some kind of interim relief, then the interim relief regarding the final decision can be given by the arbitral tribunal, and it is binding on the parties, and both the parties can be benefited by it, and it includes arbitral awards. It's itself binding. It's binding on the parties and final and enforceable. Finally, it means that no separate execution has to be filed by the parties to execute it. Arbitration or the decision, the arbitral award which is given by the arbitral tribunal, it is basically binding on the parties, and they need not have to file a separate execution proceeding or execution, and it is binding on the parties as it is a final award which is finally given by the arbitrator and finality, and it is as itself enforceable. Section 35 and 36, it clearly mentions that the arbitration clause or the arbitral award, it is binding in itself and finally. So today, with the change of the time period or with the change of the time clause, the Arbitration Act 1940 have wholly replaced by the Arbitration and Conciliation Act 1996, and it is binding on the parties, and it is a better way to go on for the arbitration, so that in case of any slight case of differences and dispute, and you need not have to go to the courts, you can abide by the arbitration clause and you can have the recourse to it, and proper decisions can be given by the arbitration, which is effective and efficient, and all the parties will be benefited without wasting any time. Thank you.